Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And we are back in Calloway County with Social Security disability attorney Jeff Roberts. Jeff, how are you this morning?
I'm doing good, Jim. How are you?
Buddy, I'm doing fine. So today let's jump into a topic about testifying at your Social Security hearing. And it takes a little while for a client to actually get to the hearing. There's a lot of other work that goes in ahead of it. So let's kind of start there, and then we'll end up with those 4 golden rules of what you need to know about your hearing. Jeff, Social Security disability, you want to just talk about that in general first, and then we'll get a little bit more specific?
Yeah, can. Social Security disability. Well, Social Security Administration administers 2 different disability programs: Social Security Disability Insurance, or SSDI, and Supplemental Security Income, or SSI. The disability determination is the same for both, as we've discussed before. The non-disability aspects are different. SSI is a needs-based program. So if you have if your assets are over a certain amount, that knocks you out of eligibility for SSI. If you have income coming in, then that would affect whether you could draw SSI or how much you could draw in SSI, depending on how much income that is coming into the household. Not just your income, but coming into the household could affect your ability to receive SSI benefits. Social Security disability is paid based on what you've paid into the system. So you have to meet what's called the insured status requirements to receive Social Security disability, which simply means that you paid enough into the system over the right periods of time to be able to receive Social Security disability. If you've worked full time for a period of time, then you're going to be eligible to, or you're going to meet the insured status requirements. When you stop working, generally, you maintain insured status requirements for approximately 5 years after you stop working, depending on how long you worked beforehand. But if you've had a good long work history and you stop working, then you'll maintain insured status requirements for 5 years after you stop working. That doesn't mean that your benefits would stop 5 years after you stop working, that you'd only get Social Security disability for 5 years. It means that we have to establish the disability occurs before you lose that insured status requirements to be able to get disability benefits.
And again, this is completely separate from workers' comp. So I know when you're hearing work requirements, you may be thinking, well, I wasn't hurt on the job, or maybe I was hurt on. This is Social Security disability. Sometimes you can get that from a workplace injury, but again, today we're talking about Social Security disability.
Correct.
Yeah.
Yes.
Okay.
And the disability determination is the same for one. If you're disabled for SSI purposes, you're disabled for Social Security disability purposes. You may not meet the other requirements to get Social Security disability, but you would the disability criteria you would meet in that setting. And the process to get to the hearing is the same for both. Both claims, SSI and Social Security disability, go through the same process. You make your initial application, which can be done. You can do that online. You can call or go into a Social Security branch office and do the application that way as well. And then that will go to the Department of Disability Services, or DDS, who will make the initial determination on whether you're disabled. Normally, they'll get the medical records. They'll have a doctor of their choosing review it. If there's a mental health aspect to the condition or to the disability, then they'll have a psychologist also, or psychiatrist, review the records as well and offer their opinions as to what kind of restrictions and how your conditions affect your ability to work. And then the disability examiner then will look at that and make a determination. Statistically speaking, you're going to be unsuccessful and you're going to be denied at the initial level. And then you file a request for reconsideration. And it kind of goes through that same process. Goes back to DDS. They get additional records. They have another set of doctors look at it, and then they make another determination. Again, statistically speaking, you're going to get denied a second time. and then you file the request for hearing in front of an administrative law judge, and that's when the case would go to a hearing office. And there's different hearing offices throughout Kentucky, and every other state has different hearing offices. If you're located in Murray or Christian County or Graves County, then it's going to go to the Paducah hearing site, is where the case is going to be venued. And one thing, when you first file the request for hearing, you'll get a notice asking, do you want or do you consent to a telephone hearing, a video conference hearing, or do you want an in-person hearing? My recommendation is to do an in-person hearing. That's what I recommend for every client that I represent, regardless of where they're at. We want to do an in-person hearing. I don't know the numbers, but the majority of communication is nonverbal. And over if you do an audio hearing over the phone, the judge is not going to pick up on any of the nonverbal communication. If you're on a small computer screen, even if the judge is looking at it big, he's seeing your head, and that's all. He's not going to pick up on you shifting in your seat because of the pain that you're in or the difficulty you had walking into the room or walking out of the room. The judge, he or she's not going to pick that up because they can't see that. That's the reason why I always want to do an in-person hearing for my clients. In my experience, I have much better results, and my clients have much better results with an in-person hearing.
Well, the thing is, you had mentioned they've pulled your medical records, they've looked at the medical records. You've obviously petitioned the court. You've probably added some supplemental documentation to those. And at that point, while, the medical records are extremely important, that nonverbal, that subjective nature of the case is actually a variable that the judge is a human being. I mean, he's going to see that, or she's going to see that, and that does play into possibly what that ultimate decision could be.
Correct. I think it can have, in the right case, it can be a huge factor. In some cases, it may not be as important as it is in other cases. But I think it is such a factor that I always want to have an in-person hearing if it's possible. I mean, if I've got somebody who, for whatever reason, because of their health issues or whatever, cannot go to the hearing site, then okay, we'll deal with that issue if we have to deal with it. But so I rarely speak in absolutes, but if my preference is to do an in-person hearing.
And because you're licensed, this Social Security disability it's federal. So
Correct.
you can help a client anywhere in the state of Kentucky, but moreover, you can help them throughout the United States. This is federal.
Correct. It's federal. I'm licensed by the state of Kentucky to practice law, but the Social Security Administration has licensed me to handle cases before the Social Security Administration in all 50 states. So I can handle a case before the Social Security Administration in any state, technically. And I have handled in numerous states. I've handled several cases out of Tennessee where I'm located. I'm close to the Tennessee state line. I've represented a lot of clients in Tennessee. Over the years, I've had several cases in Missouri, Illinois, Georgia, Florida, still waiting for the client from Hawaii to come in. But I've handled cases in a variety of different states from there and can handle them in any of the states. But one thing that I do get asked some, and I'll go ahead and say this since we're talking about the stages, is when should you get an attorney involved? And I'm of the opinion, and I know some attorneys may disagree with me, and that's perfectly fine. But I usually advise clients to come to see me after they have their initial denial. And the reason for that, in my opinion, there's absolutely nothing that an attorney is going to do at that initial level to cause a case to be granted. Cases that are granted at the initial level are granted because of the severity of the medical condition. Like I said, the vast majority of those cases are being denied. But if you've got somebody who's got chronic kidney disease and on dialysis, there's nothing. That's the type of case that's going to be granted. an attorney being involved or not involved, I don't think changes the outcome at the initial level. And personally, if I don't think I'm at least somewhat responsible for causing the case to be granted, then I don't want to charge an attorney fee in that case. But if I've done work on the case, I have to. So I tell people, make the initial application. After you get that first denial, then come in to see an attorney. Call me up or whatever attorney you wish to call up, but that's when you want to get an attorney involved.
And Jeff, you mentioned there are some situations which you may automatically qualify, and that's going to expedite that process. A while back, we did an episode on the list of impairments, the listing of impairments, and I'll make a link to that episode in the show notes. So if you've listened to this and you're wondering, hey, might I get my hearing expedited? Might I get my decision expedited? You might want to listen to that episode. But again, I'll put that in the show notes.
Great. And I won't. One word you said that I want to make a slight correction because I don't think it's automatic qualifies for it. But it is the kind that if you clearly meet those listings of impairment, it should be granted at the initial level. I've had clients where they met the listings of impairment, should have been granted at the initial level, and they still were denied. Never figured out why they were denied, but I've seen that occur. So it should occur at that point, but sometimes it doesn't occur.
So in that event, you would just pursue that as a normal disability claim and continue on with the process.
Exactly. When they get that denial, come in to see me and we'll get involved. And sometimes in those situations, there have been times where I have been able to cause cases to be granted at the reconsideration level because they misinterpreted something, they didn't pay attention to something at the initial level, or frankly, they just didn't follow the guidelines they were supposed to follow, and I've been able to point that out and cause the case to be granted at the reconsideration level. But again, most of the time they don't get granted at the reconsideration level. I know that going in that it's most likely not going to occur. We're going to have to go to the hearing to be granted in all likelihood, but getting involved at the reconsideration level lets me get my ducks in a row so I'm ready to go to a hearing much quicker than if I get involved after the reconsideration denial. Then you're 3 or 4 months further down the road for me to get all my ducks in a row before I'm ready to have that hearing.
And with 32 years of experience doing Social Security disability, obviously you've been down this road before, so you kind of have an idea of what it's going to take to best position that claim.
Correct. So then you get to you actually get to the hearing. And what's going to take place there is, when the judge is ready, they'll bring you back to the hearing room. Most of the hearing rooms that I've been in, I've had some that they've done away from the normal hearing site, and you're just more in a conference room type setting, and there's not the elevated bench that the judge sits at. But most of them, you're going into the hearing room, and the judge is sitting a little higher up at an elevated bench or desk, and there's some conference tables. The conference table directly facing the judge usually has 2 chairs, one for the attorney, one for the claimant. You'll have a hearing assistant operating hearing equipment to make sure everything is being recorded. It's audio recorded, not video recorded, even though you may have video cameras there. And used to, you would have a vocational expert in the room. Frequently now, after COVID, the vocational expert is by phone instead of being in the room with the claimant and the attorney. But all of those folks are there in the room for the hearing.
So there's not a jury. This is an administrative procedure. It's different from what you may be expecting from what you've seen on TV or maybe if you've been through a family law issue or something like that. This is an administrative hearing.
It's administrative hearing, correct. There is not a jury. There's no one else in the room besides those that I just mentioned. In fact, if you do a video conference or an audio hearing, one of the things the judge will say is these are closed hearings. Nobody else should be in the room with you to hear what's taking place or around to hear the hearing, except the people who are identified, the attorney, the claimant, vocational expert, etc., because they are closed hearings from that perspective. And you're talking about serious medical issues, they should be closed.
Yeah, that makes sense.
From there. So In generally, every judge is different. They have their own kind of way to do that. If you have an attorney, most judges will give the attorney the opportunity to make an opening statement. Most attorneys will take that opportunity. I always take that opportunity. But when you get involved to where the testimony is taken, the claimant testifies first at the hearing. And as far as what is going to be asked of the claimant, because all my clients ask me, well, what's going to be asked of me over there. And generally, the judge will start off first. Most judges that I deal with anyway start off first with some general background questions. They'll ask the claimant, name, age, social security number, date of birth, marital status, things of those, educational background. They'll go through the kind of those background questions with the claimant. Then they'll talk to the claimant about their work history, the employers that they've had it used to be over the last 15 years. I think we've done a segment on that's changed to only they just look at the past 5 years. The 5 years before you become disabled, the employment history over that 5 years. And on that, they're looking at who you work for, what your title was, and what your job duties were in that. And what I usually tell clients there, even though I'm not the one asking the questions at that point, when they ask you about the job duties, you want to focus on what you have difficulty doing now. So if it's a job that required you to stand 6 out of 8 hours a day, and now you've got a low back issue that starts hurting you after 20, 30 minutes, you can't stand that long, and we got the medical to show that, then that's one of the things you want to focus on. This job required me to be on my feet nearly all day long. At least 6 out of 8 hours I was on my feet. I was having to walk around a lot. Or if you got lifting restrictions of 10 pounds and the job required you to lift 50 pounds, I had to lift 50-pound motors or 50-pound bags of whatever, focusing on the parts of the job that you can no longer do. And the judge will likely come back in and try to focus to some extent on the parts of the job that you could do. If there was paperwork requirements, what were the paperwork requirements? Could you still do those type of paperwork requirements? So the judge may come back to that, but I want the client to focus on what they can't do. And if you have an attorney, you don't have to or shouldn't have to worry that if you don't do that, because if my client doesn't, when the judge is asking, when I get a chance to ask my client questions, I will go back in and say, well, you were talking about your job at Saputo. Did the job at Saputo, did you have to lift 50-pound bags of product and dump it into a hopper or bin and lift that up over your head and things like that? I'll go back in and bring it back and make sure the judge is aware of it, and more importantly, the vocational expert is aware of all the job all the requirements of the job that my client can no longer do. Most of the judges that I deal with, after they go through the work history with the client, and a lot of times after they finish questioning them, they will ask the vocational expert, do you need any more information about these jobs? And the vocational expert likely is very familiar with a lot of the jobs that people are doing. But then after they go through the work history, when they start talking about the medical problems and the disability issues, they'll turn it over to the attorney to ask those questions and how those medical problems affect their abilities. They'll turn it over to the attorney. But getting to the client's testimony, I have 4 rules that I basically go over with clients in prepping them for the hearing.
And I like to call these the 4 golden rules that you're hearing. Again, this is where a very experienced attorney knows how to guide you and get you ready for this type of situation. Because again, you're probably going to be nervous. You might be a little anxious. You could be medicated to a point, and it's going to be difficult to maybe on your feet, so to speak, remember all of this, but that's kind of why we're doing a podcast episode, is to allow you to have the time to go back and to review this and to think about this and to make sure that you're as ready as you can be.
Right.
So, Jeff, your I guess golden rule number one has to do with not answering until you fully understand the question.
Correct. Make sure you hear and understand the question before you answer the question. A lot of times when we start off asking the question, we kind of have an idea of where somebody is going with that question, and we want to start answering before they even finish the question.
We don't do that.
And when a couple of problems with doing that is, first, when you talk over each other, you garble up the audio record, and it makes it hard when somebody goes back to listen to tell who's speaking and what's the answer and what's the question. But also, and the other side to it is, you may be wrong on what you assume is going to be asked, and you're answering something that's not going to be asked or wasn't getting ready to be asked, but now it's going to be asked about a whole lot more. But also, if you don't hear all the question, you can't really answer a question you don't hear accurately. You cannot do that. So if for some reason, if there's some noise, if I'm beside you and I shuffle some papers, or if the judge coughs when I'm asking a question, or something occurs that causes you not to hear all of the question, then ask us to repeat the question. That happens all the time, but you want to make sure you know what's being asked of you before you start answering the question. Because if you didn't hear all the question, you may be giving an answer for something that really wasn't what's asked, but the judge has no idea that you didn't hear all of that question. So if the judge says, can you drive a car? And you're not hearing all of it, you may say yes or no to that question without realizing that, you may think that he said, can you drive a car is not a good example for from that standpoint.
Well,
but,
he may have said for an extended period of time, and you didn't hear that. You're like, yeah. I can physically do it, but that wasn't the nature of the question.
Exactly. Yeah. Can you drive a car for an extended period or for a long time? And then if you say yes, and he's going to think you can drive for a long time, even though you thought, can you drive a car, and you zoned out after the car and didn't hear for a long time, and you can only drive for 15, 20 minutes, and then you've got to get out. Well, the judge assumes you can go for 2 hours now or longer. So, and the other part is, we try not to speak in legal speak, but sometimes we do. So if the judge uses a term you're not familiar with, if the judge says, well, that job you did at Saputo, was that a sedentary job? Well, if you know what a sedentary job is, then you can go ahead and answer the question. If you have no idea what a sedentary job is, then the proper response is, I'm not sure what that is. What is a sedentary job? And make the judge go through and say, well, that's a primarily sitting job where you don't have to lift greater than 10 pounds. You're working at a desk most of the time type situation, and make them answer or explain to you what they're asking of you, because your ability to do a sedentary job may make a difference. If you're past it, if your job was a sedentary job, in your ability to do, that's one thing. But if your job was medium, where you had to lift 50 plus pounds and be on your feet 6 out of 8 hours, but you just told the judge it's a sedentary job, and you can do a sit down job, but because of your age, Social Security wouldn't require it. Well, now you just lost your case because he thinks the job you were doing was a sedentary job. If you got an attorney, they're going to correct that, but some people go to hearings without attorneys.
Yep.
Shouldn't do that, but some people do. So make sure you heard the question completely. Make sure you understand everything that's being asked. The next
golden rule number 2: give a verbal answer.
Give a verbal answer. That's the second rule, and again, that is more for the record, because, like I said, it's audio recorded. So if you have to go up on appeal, or if the judge is if the judge is usually making notes but the judge may say, okay, I can't, I'm not sure what he said to that, and wants to go back and listen to the hearing. If he or she does that, then and you nodded your head yes or shook your head no, the judge is going to not. It's not that answer is not going to be in the record, and so you need to make sure you say yes or no from that standpoint. If you're talking, if you've got a neck issue and the judge says, where do you hurt? Frequently people will say, well, I hurt from here to here, and they indicate with their hand, as I just did. But as the people listening know, the audio record doesn't pick that up. Those people listening to this podcast have no idea where here and here is. So I always tell the clients when you ask something like that, so well, it hurts at the base of my neck on the left side, or it eats into my left shoulder, down my left arm to my ring and pinky finger, or whatever the true answer to the question is. But tell us what. Don't just say point and say here to here. Tell us what you're pointing at. Again, if you have an attorney and you just say here to here, you're going to hear your attorney likely say, let the record reflect, or for the record, you were pointing at, and then describe what you were pointing at so that it is part of the record from that standpoint.
So golden rule number 3, this is again golden rules at your hearing, is give a full, complete, and honest answer. You're in a judicial hearing, a legal situation. So yeah, you probably ought to do that.
Well, and this is the most important rule. The honest part, everybody knows. That's, you're sworn in to tell the truth. Everybody knows you've got to be honest at the hearing. That's not, and obviously it's very important, but the full complete is the really important part. Because what people don't think about is when you answer a question, sometimes you can give a very short answer that is honest, but it's not accurate. For instance, I've represented a lot of clients with back issues, and the clients ask if I can you vacuum. The short answer may be yes. The full, complete, honest answer may be something more along the lines of, yes, I can vacuum, but now because of my back problems, I can vacuum one room, and then my back gets to hurting, and I've got to sit down and rest for 10 to 15 minutes, and then I can get up and vacuum another room. Now it takes me 4 hitches to get the house vacuumed, when before I could go from start to finish and vacuum the entire house. Well, if you just say, yes, I can vacuum, the judge is going to assume you can vacuum from the entire house without stopping, because you haven't told them you have to stop. The same with driving. If they ask, can you drive, the short sample answer may be yes, but the full complete answer is yes, I can drive, but after 10, 15, 20 minutes, 30 minutes of being in the vehicle, my holding the steering wheel, it affects my shoulders and my neck, and I get to hurting being in the vehicle. So after that period of time, I've got to pull over, get out, move around, stretch a little bit, rest and loosen up, and then I get back in the vehicle and drive again. And so that's the answer that I want to hear my clients give, if that's the truth. Obviously, it's got to be the truth. It's got to be an honest answer, but give the complete answer. I frequently tell people when I'm talking to them is, when you're at Walmart shopping and you see a friend and they come up and say, hey, Jim, how are you doing? It's fine. It's okay to say fine to them. But if you're doing fine, there's no reason for us to go to a Social Security hearing. So you've got to, the judge is going to assume, when you're talking about activities, he's going to assume you can do that activity the way everybody always does that activity, even unless you tell him otherwise from that standpoint. So
Perfect.
Okay.
Perfect. And so, Jeff, the fourth and final golden rule of what to do at your hearing, what to say at your hearing, comes down to don't volunteer information.
Exactly. The fourth rule, as I tell clients, is after you give a full, complete, honest answer, then be quiet and let us ask you the next question. For some reason, people don't like silence. And so when they give a full, complete answer to the question, and if the judge is kind of looking at the notes to see what they want to ask, but there's a 4 or 5 second delay, I've seen clients do it multiple times. Frankly, it's a tactic I use when I'm taking depositions of other folks, is to wait a little bit, and people will start talking again and start talking about something completely different. Don't do that at your hearing. Answer the question that the judge has asked or your attorney has asked. Give a full, complete, honest answer to that question. Then let your attorney ask the next question. Let the judge ask the next question. But if you volunteer something, you may volunteer something that's not helpful. If you've got an attorney, trust your attorney to ask you everything that the attorney thinks the judge needs to know to be successful in your case, and don't volunteer anything additional, because if it's important for the judge to know it. If you got an attorney who knows what they're doing, they're going to make sure the judge hears it.
Outstanding. And Jeff, you've got 32 years of doing this in multiple states, so you kind of understand how these hearings roll out. You understand what could be done that helps the case, and unfortunately, the little things that can be done to really kind of be a little bit more harmful to the case. Jeff, you've actually got 2 offices. Even though you can handle Social Security cases all across the United States, you've got 2 primary offices. So the first one is here in Calloway County.
Yes, my primary office is in Murray in Calloway County, Kentucky. I've been here since 1992 in the same office. And I have a satellite office in Hopkinsville that I meet with clients at up there as well. I've had that office for about 1.5 years now from there. But I have one number. I do that because I think it's just better for the clients to have one number to call. If you call Murray office and I'm in Hopkinsville, they're going to be able to get in touch with me. So you'll be able to get in touch with me from that one number. But the phone number to reach me, and phone is the best way to reach me, is to call 270-753-0053. You can also reach out through my website as well if you wish to do that. That's jeffrobertslaw.com, or send me an email at jeff@jeffrobertslaw.com from there. But I prefer verbal communication, so call if you got any questions over your Social Security disability claim. Please feel free to give me a call, and we'll see what we can do to help you out.
Thanks a lot, Jeff. I really appreciate the candid information. And friends, if you've been listening to this, once again, remember in the show notes, I'm going to link to a couple of those other episodes that Jeff mentioned and spoke briefly about during this conversation. So hopefully you'll find that helpful as well. Jeff, once again, we will see you back here in about 2 weeks. But as the motto that you've always been fond of saying right here as it relates to the Roberts Law Office in Callaway and over in Christian County, small town service with big city results.
Yes, we try to strive for that in every case we handle.
Outstanding. All right, my friend, we'll see you back in about 2 weeks.
Thank you.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.